your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys come together to engage, learn, and exchange insights on the latest developments in U.S. immigration. My name is Nikita Bahadur. I'll be your host for today's timely discussion. Family-based applications and enforcement, how removal risk affects pending petitions and deferred action formalities. When family-based immigration meets enforcement action, the stakes couldn't be higher. Many families today live in a state of uncertainty, waiting for petitions to be processed while fearing detention, removal, or the loss of deferred action protection. But what actually happens when these two paths intersect? Can a pending petition or even a humanitarian filing shield someone from deportation? To help us navigate this complex and deeply personal topic, we are joined by Attorney Wendy Barlow, a seasoned immigration attorney based in New York with over a decade of experience helping clients navigate the complexities of U.S. immigration law. Admitted to practice in multiple states and federal courts, she handles everything from family immigration, adjustment of status, to complex appeals and removal defense. As a partner at a leading boutique law firm, Attorney Barlow is dedicated to delivering excellent results through compassionate, client-focused service for individuals and families seeking new beginnings in the United States. You're welcome, Attorney Barlow. We're glad to have you back on the show.
Thank you. Glad to be back. This is a very timely topic.
Thank you. Before we begin, a quick reminder, immigrationquestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals and families can learn about immigration topics and engage with licensed attorneys who participate independently. To our viewers, it's about to get very interesting. Grab your writing pads and pens and share the link with your friends. If you have not subscribed, now is the right time to do so. Just click on the subscribe button and you're all set. Now let's begin today's discussion. Attorney Barlow, could you start by explaining how ongoing or potential enforcement actions can affect a pending family-based petition, especially for individuals with active I-130s or I-485 filings?
Sure. So one of the big concerns right now is obviously the increase in enforcement actions. Individuals with family-based petitions, whether that's, let's start with just pending I-130s, for example, especially if it's a marriage-based petition. They are being scheduled for interviews, and unfortunately, if the person, the non-U.S. citizen, the beneficiary is, if they have an order of removal, they are pretty much almost definitively being detained by ICE. The USCIS officers are notifying ICE, and ICE is coming to take those individuals into custody to effectuate that order of removal. Um, the individuals who don't have orders of removal, there is a risk that they can be put in removal proceedings, depending upon entry. That could include being detained by ICE, especially now with a lot of individuals who have crossed the border without permission, being subject to detention. And until we get better decisions from the federal court, the detention lasts pretty much the entire time of their removal proceedings. If they have other relief from removal, you can obviously pursue it, but it is a risk to be put in removal proceedings. Individuals who don't necessarily have a removal order have a legal entry. They're doing a green card through marriage, maybe, or through they have a child who's 21 or older who filed for them. Those individuals we have not seen be arrested at interviews. Though they've been relatively safe to go to those interviews, have them. Our cases have been approved. The issue is that if it's denied for some reason, so if your green card application is ultimately denied, maybe you, after the interview, they sent you a notice of intent to deny or a request for evidence, you don't respond in time, or you have a disqualifying arrest. Those individuals, upon denial of that green card application, what we're seeing now is if you don't file like a motion to reopen to try to argue it was a wrong decision, those individuals are also being sent notices to appear to show up in court. The good thing is that, again, for the most part, we're not seeing them detained. I'm sure if the person had like an active criminal warrant, that would be different. But as long as there's nothing like that, they're not actively being detained, but they are being put in removal proceedings if the application is denied. While removal proceedings may sound scary, you can, for example, if you're doing a green card application, you can ask the judge to reconsider that application. So it doesn't mean you're not going to get to stay here, but you have to do things right. And if you do have any negative history, whether it's a removal order, previously in removal proceedings, but maybe they got administratively closed or something, a criminal conviction, or even multiple arrests that necessarily didn't result in a conviction, prior fraud allegations or misrepresentation allegations, you really should talk to an attorney before you file. And if you've already filed, definitely talk to an attorney as soon as possible and before you go to any interviews, just to understand what your risk is.
When it comes to deferred action, what are its limits and protections during removal proceedings? Are there situations where someone under deferred action could still be at risk of detention or deportation?
Yes, technically, because deferred action is a discretionary grant. So deferred action can be canceled essentially by the Department of Homeland Security. So far, we haven't seen just a like overall cancellation of deferred action. It's been what we've seen has been more targeted. So it's individuals who maybe have gotten arrested or convicted of a crime. They're having deferred action canceled as a matter of discretion. Obviously, if people have been following the news, anybody with temporary protected status, which does include a deferred action component, a lot of those programs are being terminated, or maybe termination is not the right word. They're not being extended. So in a lot of cases, DHS is letting them expire. And once that expiration happens, that deferred action also goes away. But for the most part, just blatantly like ending, for example, like DACA recipients have deferred action. Just ending it, we're not seeing that unless they've triggered some other violation, for example, a criminal matter. We have not seen them cancel any deferred action, like across the board canceling deferred action for special immigrant juvenile beneficiaries who have deferred action. They have stopped granting it to new petitions, but those who have had older petitions before that policy change, their deferred action is still valid. U visas, VAWA petitioners, again, we haven't seen them putting them in removal proceedings or detaining them unless there's some other issue, which is a positive. It's one of the positives out there. Sometimes it feels like there's not a lot right now.
That is true. And for families with approved petitions who are new, who are now facing removals, what legal options or motions can help delay deportation or reopen their cases for adjustment of status consideration?
So, if you're already under an order of removal, for the most part, you can try to see if you can reopen it. Reopening removal orders is limited. For example, typically you have 90 days from the date that order of removal was put into place to file a motion to reopen. There are some exceptions to that. One exception is if you did not have notice of that hearing for some reason, like your notice to appear didn't have a hearing date in it, you never got a subsequent notice, you can seek reopening at any time. So that is one option. You can also reopen proceedings based on things like changed circumstances, but that's typically as relates to an asylum application, not just because now you're married to a US citizen or your child's 21 or older. It's not something in the past, it's not something that's very viable right now. There is it exists, but DHS just isn't agreeing. You can go to the Department of Homeland Security and ask them to agree to reopen your case. It's called prosecutorial discretion. We used a lot of that, honestly, during Biden's administration as well as Obama's administration. Right now, I can tell you we have not filed a request pretty much since the Trump administration came in, and any requests that we had pending that did not get decisions before the change in administration are being denied. So it's not really a viable option, but it's something that in a few years with a change of administration, maybe it'll be back on the table. And if there is a change of administration and you do have a removal order, but you have a path to getting a green card, as soon as that administration change happens, talk to a lawyer, be working to try to reopen your case. If you don't have a removal order and you're in removal proceedings, for the most part now, once your petition's approved, you can file a 485 with the immigration court if you have not done so, and the judge can adjudicate your 485 or your green card application. There is a very limited class of individuals who are in removal. They're called arriving aliens that USCIS does the jurisdiction, but it proportionately, it's the very small proportion of those. Again, in previous administrations, a lot of times we would be going to the court and asking them to terminate the removal to let USCIS do the green card application. Again, that's not something that we're seeing happening. So realistically, you're going to apply in front of the judge, and instead of an interview at USCIS, you'll be asked questions by your attorney, by the judge, by the government attorney, and at the end of the day, the judge will make a decision. Again, as much as removal proceedings, you should take them very seriously. The fact that you're in them does not mean you'll be removed. I just have to make that clear, because sometimes people get so scared that they'll just decide not to show up at a hearing, and that's going to lead to a removal order for failing to appear. It's always best that if you're in removal proceedings, you're working with an attorney and you're doing things the right way. The other thing is if you're in removal proceedings, you have an I-130, let's say, approved, it's your parent filed for you or your spouse, but you cross the border without its entry without inspection, or some people will say they came in illegally, however you want to phrase it. there's a small group that are eligible under an old law, INA 245I, but if you're not, you're going to have to go through consular processing. That means you're going to have to go back to your home country to get your visa. You're also going to need a waiver. If you're in removal proceedings, one of the best things you can do is file a motion to do what's called administrative closure. They essentially close your file, put it on the side. You do this waiver. Once that waiver is approved, you go back to the court. You say, my waiver is approved. I want to take voluntary departure so I can leave without a deportation order. Go to your interview. And again, we've been doing a lot of that lately. And I just, about 2 weeks ago, had a client who went through this whole process. It started many years ago. It's been a long time coming. And he returned back to the US without a problem. And he's now a green card holder. So it is something that can be done.
Okay, so if a loved one is detained while a family-based application is still pending, what immediate steps should the relatives take, and in what ways can the pending petition influence the case outcome?
So we'll start with what the relatives should do, because it's obviously two different paths. So the relatives, if you don't have an attorney, you need to talk to an attorney. Removal proceedings are not something you should be doing by yourself. There's a lot of very strict deadlines. There's rules. You could be filing things with the wrong thing. Not that the judges are going, like most judges are not going to yell if someone's pro se, which means representing yourself, and you file something and it's not right. But it can also annoy a judge too that things aren't being filed properly. And that's never a good place to be in. But you want to see, so if you, let's say you have the whole green card package pending and you get arrested for a crime, the police hand you over to ICE. Now you're sitting in detention. You may or may not be bond eligible. So that's the first and foremost what we do when we talk to a family member. Let me back that up. The first thing you should do, if you're the person detained, do not sign anything that ICE gives you. I'm not saying ultimately you won't, but don't rush to sign it. Tell them politely that you want to talk to a lawyer first before you sign anything. The reason I say that, I've heard a lot of stories. ICE will put a lot of pressure on people to sign documents waiving rights. And then next thing you know, you're being deported when you would have had a chance to fight the case here. But you gave that right up. So do not sign anything unless you fully understand it, and better yet, you've talked to a lawyer. Number two, if your case is pending, working with a lawyer can try to help get that I-130 expedited if you're detained. They can also explore whether you're eligible for bond. If you're eligible for bond, you can file a bond motion. You have to show the court you're not a flight risk or a danger to the community, and the judge will make a ruling. They set bond, your family post it, now you're back out free. Case will be ongoing whether or not you get to stay here, but at least you're not sitting in detention. They can expedite I-130s. Once that's approved, then the judge can get to your green card application. If only you have an I-130 pending and you may not be eligible for adjustment of status, maybe it's because you're an adult child and your mom filed for you, or your spouse is a lawful permanent resident. The first thing would be to explore other relief, but if there's no other relief, as much as people don't want to hear it, sometimes the best option is to take what's called voluntary departure. That's where you agree to leave the country in a set amount of days. As long as you leave, you have no removal order, and that makes one less hurdle to try to come back. It doesn't mean you're never coming back to the US. You just may have to return home temporarily while the rest of the stuff works its way through the system, and then you come back.
Okay, and how do current DHS enforcement priorities and prosecutorial discretion policies impact families with pending or approved petitions? Are there practical ways families can advocate for favorable discretion under today's enforcement framework?
So prosecutorial discretion is prosecutorial discretion at this point is extremely limited. It's almost non-existent. It technically exists, but it's not being executed. And right now, and I'm not trying to be doom and gloom or scary. I just want people to realize right now, ICE has quotas. They won't say they have quotas, but they totally have quotas on deportations they are expected to make. So you're in a situation where they're trying to make quotas. The government wants to deport as many people who don't have status here as possible. Now, yes, can you go to ICE? Have we been successful going to ICE saying, look, this person's here for their check-in. They're now married to a U.S. citizen. They're eligible for the green card. We filed already everything with USCIS already. Here's a copy of the package. Can you give us another appointment? We have had success when that person is eligible to get a green card here and does not have anything negative, like a conviction or anything. But that is the exception, not the norm. So it is a very scary time, and just having that I-130 unfortunately is not going to just protect you from anything.
Okay. Thank you so much, Attorney Barlow. To everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for being part of this essential conversation. Whether you're an H-1B professional navigating uncertainty or an employer seeking clarity, this discussion is about awareness, preparation, and informed decision-making. Suppose this is your first time joining us, welcome. Question.com is a network platform where immigrants, families, and employers can ask immigration-related questions for free and engage directly with licensed immigration attorneys. You can participate in any language, and many users may also qualify for a free confidential consultation. We're also proud to share that immigrationquestion.com is now BB accredited, a recognition of our ongoing commitment to transparency, accountability, and service to immigrant and business communities across the United States. Attorney Barlow, as an immigration attorney with experience in family immigration and deportation defense, what are your thoughts on how a platform like immigrationquestion.com is helping immigrants and attorneys network effectively?
I think platforms like this one are helpful. It's a good way for people to be able to ask some initial questions, get some information, get introduced to attorneys who they can then contact and see, one thing you have to be able to work together. So sometimes I've been in this situation, personalities clash. You're not going to be a good fit for each other, but it's a way to help you find someone that you trust, that you feel like you can communicate effectively with. So that's good. And again, it also gives you basic information so you can see, okay, this is what I can do, or okay, maybe I'm eligible for this, but let me talk to someone and make sure I'm reading this correctly before you proceed. So they are helpful, especially when things like the information is vetted, because nowadays there's a lot of misinformation out there. And not to disparage AI, so your Chat GPTs, your Gemini, your Grok, whatever one is your AI of choice, they can be very helpful with things, but they are not a substitute for actual information coming from a skilled professional, whether that be through a platform or contacting someone. I've seen a lot of people come in and said, I looked this up on AI and rattle off all the stuff. I can do this green card, right? And I'm like, no. So these platforms are helpful because they do help get the right information to you and connect you with attorneys that can help you.
Thank you for that perspective, Attorney Barlow. Before we get into the live Q&A, there's one more question from me. What proactive steps would you recommend for families in mixed status situations where one member is undocumented and, well, one member is undocumented or under deferred action to reduce enforcement risk while continuing to make progress on their immigration petitions?
First and foremost, may work with a knowledgeable attorney. Make sure you are eligible for what you are filing for, because if you're not, you're just putting yourself on the radar potentially. Because if you're not eligible for this petition and it's ultimately denied, then one of the things that's on pretty much every form you ever file with immigration is your address. So they will know you're here. You will put information in about that. So that's first and foremost. Two, know your rights. There's a lot of stuff out there publicly available. If you are detained or encountered by ICE, you technically have the right to remain silent. Doesn't mean they can't detain you, but you don't have to tell them, oh yeah, I'm from Mexico or I'm from India. I don't have any papers here. You can keep your mouth shut essentially. And sometimes that's a very good plan. Three, like I said before, don't sign anything away before you know what you're signing, because you could be giving up very valuable rights. And the last thing is, if you are here undocumented and you are in a mixed or blended family, but you don't have anything going on, you really should still talk to an attorney. I know I've seen the social media post. I've heard the stories. I'm following all this stuff with you. I know it is scary, but if you do, you may be eligible to fix your status here. And then that takes that fear away. Hiding away doesn't help. If you're eligible to get a green card here and you're just hiding and now ICE comes and now you're working backwards versus if you start proactively. For example, I've talked to a lot of individuals who don't even realize they're grandfathered under INA 245I. It's an old law about, like, if you were here or the beneficiary of a petition filed on or before April 30th, 2001, as long as that petition was approvable when filed, you can use that to excuse coming across the border, being here without status. And what we're finding is, not necessarily as many principal beneficiaries, meaning the person the petition was actually filed for, but their kids. So you'll have a family who maybe they came across the border. Kid was like 2 years old, doesn't know anything, came across the border. Father, mother was a beneficiary of a petition filed by an old employer. Never got their green card through it, but now this kid's married to a US citizen. And they're like, oh, I can't do anything because I crossed the border. No, you were a derivative. You can take advantage of that grandfathering and get your green card. So be proactive. Talk to an attorney. That doesn't mean just go to any attorney, please. Again, there are a lot of resources. Find a reputable attorney. There are great attorneys and there are horrible immigration attorneys, just like in any legal field. But there are individuals who unfortunately take advantage of immigrants. They will also do things that is not maybe legal, and sometimes people don't understand what exactly they're doing. I always tell people, if it sounds too good to be true and the person's not giving you information to explain why it's true, then you probably should go get a second opinion. For example, if you came to me and I talked to you about this grandma, I would show you the law. I would explain how it applies to you, why you're eligible. If they're just saying, if you do this, you can get your green card or get a work permit, be wary of that. The other thing too is promises. Be careful of promises for work permits. In general, work permits are not individual applications, meaning you can't just get a work permit because you want one. They are tied to some other application. So that means you are filing some other application that makes you eligible for this. You may find yourself in a situation where you don't really understand what you're filing. So again, be clear. Don't be afraid to ask questions when you're in a consultation or you've hired a lawyer. If they're evasive or don't answer your questions, that's not a good lawyer for you. Walk away.
Thank you for that. So, if you're just joining us, we've been in an insightful discussion with Attorney Wendy Barlow on the topic family based applications and enforcement, how removal risk affects pending petitions and deferred action families. We're now moving into our live Q&A session. This is your opportunity to ask your questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as possible during the session. Okay, our first question is, my I-130 was filed before August 1st, so will new USCIS rules still affect my case?
I'm trying to understand which new rule he's referring to. There hasn't been very many changes with I-130s and USCIS beyond, again, if things are denied, sending things to removal proceedings if someone is out of status. Documentation wise, yes, they are indicating there'll be a little bit more scrutiny on applications, but there's nothing that's like, I just don't understand. I don't know which rule he's specifically mentioning, or she is mentioning. If they want to provide more clarity, I'll be happy to try to be more clear in my answer.
Okay, our next question. They say my I-130 approval do not mean I am safe. Can immigration still deport me?
So an approved I-130 does not give you status in the US. It gives you a path to status. An I-130 it's an immigrant visa, which gives you, again, a path to get a green card here, whether that's through the adjustment of status or through consular processing. That's what that does. It does not protect you from removal by itself. And unfortunately, if you are here without status, you can be removed even with an approved I-130.
Okay. Our next question. Okay. I entered without inspection long ago, but my spouse has filed for me. Will USCIS send notice to appear?
Potentially. We have not seen a lot of that happening yet. We have individuals who are getting, who are still, because we're still doing these processes. We haven't seen anybody just because of the I-130 getting a notice to appear. What the risk likely is for you is when you're scheduled for an interview, because pretty much all spousal petitions have interviews now. And when you go to that interview and you're out of status, there is a chance that you could be called, like ICE could be called, and you could be taken into custody. That's probably where the biggest risk is, not just the filing of it by itself. You know, it is an unfortunate situation. The problem is if you don't go to the interview, then you can't have the petition approved and proceed to get status. So it is a risk that you have to consider. If you and your wife are scheduled for an interview, or your spouse are scheduled for an interview, you should definitely make sure you talk to an attorney before you go to that interview and understand what the risk is, especially at the local office where you're going to be interviewed. Because not all offices, you know, obviously there's policy coming down from Washington, but each office, you know, maybe they only call ICE when they're done the interview and they tell you to get out of the office. I've had that happen years ago where someone's like, I called ICE, they didn't show up, I'm done, have a nice day, and told us to leave, you know. And the officer's policy was, they told me all I had to do was let them know they were here. It's not my job to hold you. So, but just make sure you understand the risk at the, of what's going on at the time you're scheduled.
Okay, our next question. Please, can a deferred action person get EAD while fighting removal?
They can, depending on the basis of the deferred action. Some deferred action allows you to apply for a work permit or EAD. Others do not. It will really depend on the basis of your deferred action. One of the things you can do is you can go to USCIS's website, look at the filing instructions for Form I-765. That's the work permit application. You can look at that and see if they have categories, and you can read if your category is there. Otherwise, let someone talk to an attorney about what category you have, and if you're eligible, either they'll tell you and you can apply, or they'll assist you with applying.
Okay. Our next question. If a visa officer think my marriage is fake, can they send us direct to court without warning?
Well, I'm assuming by visa officer you mean a USCIS officer. Visa officers usually referring to when you're overseas, and I don't know what court they'd send you to. I mean, I guess they could have you arrested for fraud in your country, but they usually just deny you for fraud and send you on your way. But if they suspect your marriage is fraudulent, so USCIS does multiple things. They conduct interviews. If you have a first interview and they're not satisfied, they can do a couple things. They can send you a request for additional documents and let you respond. And they can also schedule you for a second interview. Sometimes it's called a Stokes interview or an investigative interview. That's usually the interview what people think about, or the movies, or, and that's where the couple is separated. They're asked a series of questions. After that, they're brought back together, given a chance to discuss any discrepancies between them. And depending on the outcome, it can be approved or not. If after that they suspect that the marriage was entered into fraudulently, they will deny the I-130, and you are very likely going to be put in removal proceedings.
Okay. Our next question. Okay. I applied for F2B visa. If they find small mistake or missing doc, will they give me a chance to fix it or deny automatically?
Pretty much, if it's a small mistake, depending on what it is, you can notify USCIS of that mistake in writing, or this consulate if you're doing consular processing. If it's missing a document, like a required document, usually USCIS will send you a request for evidence and give you a chance to submit it. Again, if there's some kind of discrepancy, they may also indicate that in a request for evidence and ask you to explain. If it was unintentional and a minor, ultimately it's probably not going to lead to a denial. And usually anything negative that comes up, whether it's a missing document or negative information in the file, you are sent the request for evidence and given or notice of intent to deny and given an opportunity to respond.
Thank you so much, Attorney Barlow, for your time, your expertise, and clarity today. Your insights have helped shed light on a complicated intersection between family unity and enforced policy, and provided hope and practical direction for so many families tuning in. And to all our viewers, thank you for joining this meaningful conversation. We hope today's discussion helps you stay informed, empowered, and proactive in protecting your family's future. Remember, you can always visit immigrationquestion.com to ask your immigration questions for free and engage directly with licensed immigration attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's webinar or reshare with others, the full replay will soon be available on Spotify. Search Borderless Talk by immigrationquestion.com. Join us again on Wednesday for another live session where we continue exploring immigration topics that matter most to you, from family unity and humanitarian relief to employment visas and compliance strategies. Once again, thank you, Attorney Barlow, and thank you to everyone who watched. Until next time, stay informed, stay protected, and stay connected.
Thank you. Have a great day, everyone.